And then just for the session itself, if you are at any point, if you want to ask a question, you can either raise your hand or you can pop it in the chat box. We'll see if we haven't addressed it by the end of the session, if we can address that for you. You're welcome to introduce yourself. If you want to ask a question anonymously, feel free to do that, sending it directly to me, Crystal Austin, as the host, and then we'll answer the question without it necessarily being identifiable. So you're more than welcome to do that as well. If there are any specific questions that you feel we haven't answered during the session and you would like an opportunity to ask it after the session, we will also give you Basil's details and my details for you to be able to reach out to us. Welcome, Basil. Right, so I'm glad you got through that technical protest to be able to kick off the session this morning. So again, as I said, thank you for just for accommodating us there with the slight technical issue. And I'm hoping Basil had a challenge getting into the session. I'm hoping other individuals don't have the same technical challenge this morning. So Basil, just to kick off, we've got a few people in the waiting room already. The meeting is being recorded so that we can send it out to registrants who weren't able to meet it or to make the session with us today. So I'm just going to advance the slide, and it will be interactive between Basil and myself. And as I said, please pop in any questions as and when they come up for you. Right, so just about who we are. Basil, would you like to introduce yourself very briefly?
Hello, I'm Basil Smith. I'm an HR professional with a proven track record of more than 40 years of improving people, performance, and organizations.
Right. Well read, Basil.
Thank you, Crystal. I can read.
And that's just, I mean, Basil's being very limited here into what his actual skills are. But yes, you'll see throughout the session, he knows far more than he's admitting at this point. And then just for myself, I'm an assessment specialist. I represent a few companies in South Africa as a distributor as well as a trainer, but with a specific focus on understanding how people are showing up from an emotional intelligence perspective, organizational behavior. So what are some of the things that we need to be aware of in how we interact with people, and especially now with what it is that we've gone through. And so you'll see our session will include a little bit of both as we go through it. Basil, just the commitment that we have made, as we've said to everyone here, is we are happy to reach out to you, answer any questions either during the session or post the session, but you'll have our details. So if a week or 2 weeks from now or a month from now, any of these questions come up for you and you're just not entirely sure, please reach out to us. We will do what we can on our side to help guide you in the right direction. And as I mentioned, the multi-phase approach, we're going to talk a little bit about understanding the emotions that the people are experiencing at the moment, why that is important in the context of what it is that Basil's going to be addressing from the solution side, some of those questions that we're getting asked at the moment. And then also understanding what it is that you need to do to prepare yourself for going forward. So let's kick off. Looking at statistics, and I know we've been thrown so many statistics in the last week or two, but the average person has approximately 15,000 thoughts per day. That's overwhelming, and they're not necessarily conscious. We're not even aware that we're having so many different thoughts per day. This can range anywhere between 15,000 to 60,000 thoughts per day. But with the statistic, about 50% of the thoughts we think on a regular day are positive, and the other half are potentially negative thoughts. So that is not in the context of what we've currently experienced. So what I would like each of you to do, just briefly, personal little exercise for yourself, is to just reflect on the last 24 hours, purely the last 24 hours. Write down, and you can do this either now during the session or you can do it for yourself after the session, is I want you for the next 60 seconds to just write down as many emotions or feelings you remember experiencing. It can be in any context. So was it related to your business? Was it related to your personal life? But for the next 60 seconds, I'm going to just keep quiet and I'm going to ask you to write down as many of these emotions as you recall experiencing. The good, the bad, and the ugly. So timer is going, and we'll give you 60 seconds of silence to just focus on this activity quickly. Right. So just if you look at what it is that you've written down, consider how many of the emotions and feelings you've just experienced over the last 24 hours. To what degree do you have positive emotions and feelings compared to negative emotions, or those unproductive, any feelings that might be preventing you from thinking clearly, that might be draining your energy? This will give you an idea of what your ratio of positive to negative thoughts have been in the last 24 hours. Every thought we think has an emotion attached to it. You can also take this exercise and reflect on the last week or the last 2 weeks, which brings us to what we refer to as the science of emotions. Why do we need to understand the impact our emotions are going to have on what we're going to be able to achieve going forward? So if you think about the events that we've experienced over the last 2 weeks, everything that comes at us, our brain filters it through what we refer to as the emotional brain, or the amygdala in the middle of our brain. It decides if something that's just happened, is this good for us? Is this a useful event? Or is this something that is potentially threatening? It's something that is dangerous. It's something that's not useful for me. And based on that information, the brain decides just those two, literally, is this good for me or is this bad for me? Based on the decision, if something is useful, or if it's a good decision or a good event, it puts us into a much more engaged zone. It helps us to think more freely. We become more creative. We're just expansive in how we look at the world and look at things. If you think about the events that you've experienced over the last 2 weeks, and even what it is that you're facing now, think about what state you've been put in. And most of us, if I think about my own experience, it was immediately a threatening environment. When we heard that there were riots and, we've got COVID lockdown, all of those problems compounded, we were placed into a threatened state, something that is not useful for us, something that really has put us almost into survival mode. What is it that I need to do to protect whether it's my immediate family, my community, or my business? Now, when we're triggered into that threatened state, what happens is we become narrowed in our thinking. We can't see solutions as clearly as we need to. We can't think about how to move forward effectively. We start disengaging from things that would normally have our attention. And then if you also think about whether it's your immediate family, community, or your staff, what states were they placed in during this time? Now, why do we need to know this? Based on what my brain has tagged this event as, it's going to impact 3 very important things. It's going to impact the way I think about things. Now, we know, as I just mentioned before, every thought is connected to an emotion. Emotions are connected to hormones in our body, stress hormones, the anxiety that we're experiencing. That's where you can feel the trigger in your body. You're either shaking, or you can feel you're anxious. You've got that knot in your stomach. Your mind, you're finding it difficult to be clear about things, knowing how to move forward. It also impacts then on the types of decisions that we make. What is the right thing to do? What is the logical thing to do? What is the human thing to do? And those decisions impact the way we show up. It impacts the way we behave towards each other. And we've got various examples of different types of behaviors based on how our thinking brain has now interpreted the event. we're going to give you a little bit more insight as to why we're touching on this. Why is it important for me to know what state I've been triggered into, and how do I shift from a feeling of feeling threatened and unsure into a state where I can be open and expansive and move into something that will be productive and positive for us going forward. And then just as we mentioned earlier, Basil, and you can pop in here as well, think about how people have behaved in, whether it's the last week or 2 weeks. How many times did you see on, whether it was your community groups, people making assumptions around whether it's COVID or what was happening in our immediate surroundings? What kind of behavior did you see displayed? How many aggressive individuals did you see? Or how many aggressive events did you hear about? Think about how communities responded to what was happening around them. How many of those responses were reactive? It's me doing the next best thing, I think, whether I've thought it through logically or not. And how many problems have you seen surface as a result? And what I'm showing you now is the external behaviors. These are the things that are marked in red here. This is how we're seeing people show up in the workplace. It's how we're going to see people show up in our communities. This is what we're going to see in external behavior, which is really a symptom of the underlying cause. It's the emotions that people are feeling. Think about some of the words that you wrote down. What is it that you experienced? What are some of those thoughts that you had? When people feel anxious, they become reactive. When people are feeling stressed, it's a coping mechanism. It's a protective mechanism for me to be aggressive. I have to defend what is mine. I have to defend what it is that I've got. But also, when we're not sure about things, we see the fake news being spread, and it spreads rapidly. Counter to this is when people, if you think about how communities very quickly stepped out of that threatened state into a productive state, people then very quickly moved from, oh my word, this is happening to me, to, hey, what can I do about it? Because they had time to think about what just happened, and I can either react or I can be proactive and do something that benefits other people. So to what degree did you see people engaging in a way that they've never done before, where they reached out to care for their neighbors, where they started coming up with solutions that we wouldn't even have considered 2 weeks ago, and now people are coming up with new ideas, new ways of doing things. So we're going to go, based on some of these things that you're aware of now, we're going to present you with some logical facts, things that you can be aware of when you are now going to be addressing some of the advice that Basil's going to give you, some of the tips that he's going to address based on those questions that you pose, as well as what we've got presented for you. Basil, any comments?
No, Crystal, I think that's great. I'm sure there may be questions that people may be having, and we can deal with those along the way.
Great. Yeah. So then just that recap again. The way we feel is going to impact our decisions, the way we behave, and then ultimately our performance. And for you now to think beyond yourself, how are the current emotions going to be affecting your staff, your families, your communities? So Basil, we're going to launch into the questions and answers, and this is where, as the expert, you're going to be addressing these. If you have any questions, as I mentioned earlier, based on what we're discussing, please pop it in the chat box, and we can elaborate on any of those that you may have. So Basil, first question. Is an employer legally obliged to pay staff who have not attended work for the past week or two now, or since the protests, or even during the protests?
Do you want an answer for that?
I would appreciate an answer.
Well, the short answer is no. The principle of no work, no pay, which I think most people are familiar with, would apply. However, there may be contracts of employment that are very generous and very sympathetic and people-focused, which actually may make provision for payment for stayaways or for an inability or incapacity of an employee to attend work, in which case you would have to give consideration to applying those terms and conditions which may exist in your contract.
Right, so no work, no pay. Anybody, if you've, as I mentioned again, if you've got a question, does anybody have a question on this that they would like Basil to elaborate on? Just, you can either put up your hand or just pop it again into the chat box and we can address that for you. Second question, my premises or plant have been destroyed and I can no longer conduct business. Do I still have to pay the staff?
The answer is no. You do not, and you possibly cannot or won't be able to pay the staff because of what has happened to you, or what your business has experienced as a result of the riots or protests or looting, or a combination of all of the above. The principle here is that the actions by third parties being beyond your control and beyond the control of your staff have in fact made it impossible for you to conduct business. The common law under these circumstances actually comes to the rescue. Where this situation has occurred, where it's impossible for either party to exercise their respective contractual obligations, the contract is accordingly extinguished. And that term is used in common law, extinguished. It is made null and void.
Right. Any questions from anyone? Anyone need further clarity on this comment? Right. So I'm just going to, if there's nothing, we'll address the next question then, Basil. Okay, what do I do now? So employee-wise, staff-wise, based on those first two questions, what is the best thing to do now?
What you do now is a factor of your relationship with your staff. But there are certain basic principles that you'll need to actually bear in mind and to apply. First of all, the principle of communication. Communicate with your staff verbally or preferably in writing, explaining that the business cannot continue to trade. You may have staff that has, in the course of this week, arrived for work seeking continuation of contract or seeking to continue working. If that's not the case, or if you're still anticipating that, then you need to determine the state of your business. And if you cannot trade, then you simply advise that all the contracts of employment have in fact been terminated, or extinguished, as I said, by virtue of the application of the common law. In effect, you do not have any staff left, as it were, simply because of the termination of contract by virtue of that principle. And so you would then start to make arrangements for the recovery of any and all property which they may have in their possession. Now, it seems a rather cold move, but please understand, because you have no business left, or you are in the state of declaring your business to be non-functioning, that means that you actually don't have any staff per se. So in speaking to the people in front of you, they need to be informed that they are no longer, and you are no longer addressing them as employees, but certainly as people who were former employees who may have property in their possession.
And then Basil, what's the, when you say the property, company property, what kind of things would that include?
Well, it could be quite sophisticated in terms of they may have company vehicles, which they used. They may have computers. They may have documentation, files, either hard copy files, or they may have memory sticks or other information belonging to the company, which was necessary for the company to continue operating. And so these things have a value, either in terms of a material value, in the case of a sort of hard materials such as vehicles or PCs, etc., or they might have intellectual value. They might have information pertaining to your clients or your business trading, and you do not want that to be in the public domain. And there may be a situation where, in fact, you wish at some future stage to start anew, and all that material and or intellectual capital you'll need to have on hand.
And then also, the time period, Basil, is there a recommended time period? We're talking about terminating certain contracts. What is a recommended time period within which to do this? We've seen people almost wait, well, should I wait a month or two to see if things get better? Or is it a matter of, what we've kind of identified that today it's difficult for us to carry on. We can no longer continue. How soon should people be either terminating these contracts, reviewing these contracts, or trying to recover the property?
Think in terms of perhaps a scale and a musical scale between an octave of 8 notes from, and I'll use jargon, C to C. There's a variation of notes in between the lower C and the upper C. And so you ask what time period. The term that's been bandied about for over the years in labor law is the term of reasonableness, and another horrible term, which is fairness. And it's very difficult to actually put concrete time periods to things such as this, because the question that will effectively be asked is, are your actions reasonable and fair, but under the circumstances? So each person's circumstances may differ, and each case will be needing to be considered, or will be considered if it had to go to a CCMA, labor court, etc., on its own merits. So if you ask for what time period, a time period that is reasonable. Now, how do we determine reasonableness? On the facts of the matter. However, there are those notes that I spoke about in between. You may need, notwithstanding the fact that you do not have a business, you may need to communicate with employees by indicating to them the likelihood of the business opening again at some stage. And clearly you can't commit to a time period when it comes to reestablishing a business, especially if your physical property has been destroyed. But you may have a relationship with your employees which has been long established, and you would in fact like to retain the services. You could, without making any kind of fixed commitment, indicate your preparedness at some stage to re-employ or to employ anew. Where in a situation where your business is partially incapacitated, I'll use that term, or partially destroyed, and you can, within a relatively short period, recommence trading or service providing, whatever the case might be, you may then engage with your employees and suspend their existing contracts of employment. Where there is insufficient grounds to justify the common law application of termination or extinguishing of the contract, you may wish to suspend those contracts for an indefinite period. And the suspension of those contracts may be, and we'll deal with that a little bit later, but the suspension of those contracts may be in terms of any agreement which you have, any kind of subordinate legislation in the form of a bargaining council agreement that you may be party to, or in terms of a sectoral agreement, which normally comes in the form of a wage determination. So you'll need to have a look at the fine print should you wish to retain the services, in other words, not terminate, and pend these for a later date. I'll touch on the issue of retrenchment a few slides ahead.
So let's have a look at the next question then. So if or since I can no longer trade because of right damage, must I pay severance compensation as per section 189 of the Labour Relations Act to my staff whose contracts are being terminated?
This answer comes in two forms. Firstly, no, because the termination of existing staff is under the common law principle and not the labor relations principle. And the common law principle of supervening impossibility of performance actually trumps section 189 of the Labor Relations Act. So if you are terminating staff because of the right damage and the fact that you will no longer or can no longer be trading, the principle of common law comes into effect, and there's no liability in terms of the Labor Relations Act. Having said that, however, if we look at the next slide, here comes the definite maybe. And this is in situations where part of your business is affected. For example, you may have salesmen out on the road whose objective right now would be to sell as many services or material goods as possible in order for you to generate revenue, but you may have a warehouse of stock which has been razed to the ground. So one half of your workforce are encouraged to work flat out, while the other half, you have no future for them at this stage. And this is where this Section 189 of the Labour Relations Act may come into effect. Since your business is still trading, there still exists a relationship between employer and employee. But that relationship is practical only in terms of applying to your sales force. When it comes to your stock controllers or receiving or whatever the case might be on the other side of your business, which has been destroyed, you may well be in the situation where that part of your business can no longer continue. And this is where the possibility exists that you may be obliged to pursue a termination on grounds of Section 189 of the Labour Relations Act. Now, at this stage, I would like to give you clear direction in this regard, but this is going to be a first for many employers and employees, and also a first for the CCMA. Now, I last experienced this kind of situation in the early 80s, before or in the early days of the Labour Relations Act, when it was first promulgated, when I was employed as in a company in the agribusiness, and the location of that company was in the middle of a township here in KwaZulu-Natal, outside Durban. And there was civil war taking place between what was then the MDM, the Mass Democratic Movement, the United Democratic Front. It wasn't then the ANC, it was still early days. And Inkatha, in its guise of the United People's Union of South Africa, UPUSA, and then the police and the army. And in effect, what was happening is that the civil unrest in the townships extended to murder, burnings, lootings, whatever the case might be, which actually made it impossible for employees living in that particular township to actually come to work. If they were on the road, they were assassinated. If they were in their homes were burnt down, and so many of them fled to no man's land. But for those employees who lived outside of the township, they were able to access the factories and attend work. Now, that was really early days, and the case law surrounding Section 189 hadn't, in fact, been developed. But we took a two-tier approach to the staff at that time, accommodating those sympathetically who could not attend to work without any punitive action, and then extending to those who could attend work but who could not work because the factory couldn't operate, on such things as extended leave, leave in advance, short time, and such the like. So you might need to be creative at this point in time with your staff if you are in this number 2 situation. Please, we can give you some advice, but this is going to be a new experience for many of the commissioners at the CCMA. And I'm expecting weird and wonderful judgments to come out of the CCMA in this regard.
Right, Basil, and we're going to get through this because I see a few people do have questions that are coming in, which are really valid, that we're going to try and address for you as well. So the next question, Basil, is what if my business is not damaged but is adversely affected, being unable to trade profitably because customers or suppliers are in turn unable to trade because of their respective protester-caused damages? So that chain reaction effect that we're seeing and that we experienced, I think, even with our supermarkets not being able to supply us with stuff because they couldn't get the foods in.
All right, I have alluded to that perhaps in my monotone that I discussed with you previously. But this is another case in point where, through no fault of your own, you may be constrained or prevented from conducting business, in which case, on its own merits, the principle of common law may need to be applied. That it's a force majeure, and if you don't have any reference to force majeure in any of your contracts, and it's unlikely that when you drew up many of your employment contracts, that was the last thing you had in mind. And in my experience, the force majeure principle would apply to trading contracts or between companies, business to business, but would not necessarily apply in the employment-employee relationship. So in the absence of that provision, which would have protected you and enabled you to make decisions in these circumstances, you may need to resort to the common law. But please, the importance here is that each case needing to be determined on the facts.
So Basil, I'm going to give you a question here, which relates to some of the points we've just spoken. So maybe just elaborate again. What is common practice regarding no work, no pay in terms of the contract? Would an employer deduct leave or merely pay them out of goodwill? You know, so I think it was one of the first slides, you know, people weren't able to attend. What is common practice?
Okay. Sure. Common practice is sometimes it's the lowest common denominator, which tends to be applicable to most, but not really comfortable. And so when we go to common practice, what employers normally do is they phone a chamber of business or they phone a non-legal establishment. In other words, a non-legal establishment being other than, for example, a bargaining council or a sectoral advisory body. And they get an opinion as to what the other person is doing, and they think it sounds like a good idea, and they apply it. And in applying it, they may refer that to someone else, and that then becomes common practice. But it's common practice without necessarily any legal basis. And that is important. So we don't want to just look at what is common practice. We also want to look at what is legally acceptable or lawful. And so when we come to such things as, okay, the fellows aren't coming to work, they're not getting paid, Can I deem their absence to be annual leave? Well, yes and no. If you have clauses in your contract of agreement which specifies, for example, that your annual shutdown in your business is over the Christmas period or the December period, then you will, in effect, by granting them leave, unless you are still going to grant them the December shutdown leave, you will in fact be changing the terms and conditions of a contract which you have entered into unilaterally, in which case you open yourself to a dispute by employees who, under these circumstances, obviously would like butter on both sides of the bread. They would like paid leave at this time, and then at a later stage to negotiate with you how they're still going to have their December break on full pay. So please be aware of the fact that you are bound in terms of legislation. There is annual, there is the annual leave allocation, all right, as per the Basic Conditions of Employment Act or a bargaining council agreement or a contract of employment, which may be superior to the Basic Conditions of Employment Act. You need to take those into consideration as well. For example, you may enter into a negotiation with your employees or a consultation with your employees and agree to amend the terms of the contract of employment. If you do that, you are able then, through that consultation or negotiation, to come up with an amendment and to and that then makes any change that you want to implement lawful, because it is uh, an acceptable lawful principle that with the agreement of an employee, an employer may change the terms and conditions of a contract. So yes, you can grant them leave. You can deem this to be paid or unpaid or even partially paid or any variations on the theme, which if you arrive at that by negotiation, then you're safe. It's agreed. Watch out for unilateral changes, even though those unilateral changes are made from the heart to benefit the employees at this time. Because by making those unilateral changes, you might get acceptance on the part of the employees on receiving pay. Thank you very much. But then they reserve their rights by being quiet or tacit in respect of the applicability of such things as an annual leave paid over the year-end shutdown. Watch out for that.
Right. So another question for you. We have a garden service business. All equipment was held in the storage facility, which was looted, so no machinery left to continue with our business. Should we give or sell our customers to another service provider? And what would be our obligations to the staff? That's a very good question, Basil.
First thing, you could declare your business as a business to be extinguished in terms of all the contracts that exist between yourself and your staff. In other words, you can no longer, you're no longer trading. By as such, the employees then lose their employee status, and you would not, under those circumstances, be obliged to pay any kind of reparation in terms of Section 189 of the Labor Relations Act, which is the retrenchment benefit, because of the common law supreme principle being applied. Any kind of arrangement that you then wish to make with any other contractor in terms of goodwill or your books or such the like is done so independently of any kind of contract relationship you will have with your employees who are no longer your employees. So it wouldn't be the same as per the Labor Relations Act, where a business is sold as a going concern, and then the liabilities for the payment of benefits such as long service award, leave, all the terms and conditions, etc., which then transfer simply from one employer to the other. That would not apply if you apply the common law principles of supervening impossibility. You may wish to, however, engage as a mediator or a facilitator in facilitating their employment, but be very aware and conscious of the fact that you need to expressly and explicitly advise your employees of the extinguishing fact of their contract with employment. I don't know if that that helps the person who.
Right. So yeah, I mean, if there's any further questions, please feel free to just reach out. If you do have any extras, we can also address that for you after the meeting. The next one, Basil, this is actually very interesting one. Our building was destroyed and burned. So this included our employment contract. So the data that they've been keeping about their employees. So what do they do now in the case of an employee coming forward and saying, I want a copy of that contract?
No, you can't have one. Right. Technically, if you were engaging in good employment practice, you would have had a contract, and the employee would have also received a copy of that contract. So it may well be that the only remaining evidence of a contract is that which is in possession of the employee. Right. That was, and it may not be that you as an employer have become so competent that all your contracts are sitting in the cloud and you can simply recover everything that where the hard copies or the hard drives or whatever the case might be have been destroyed, where you can set up again and simply download everything from the cloud. If that is the case, then it would be in your interest to do so. However, it may not necessarily be a possibility. So if your buildings are destroyed, I'm assuming then that the question is asked because you would like to continue business, or you wish to identify any liabilities which may exist. Once again, on the facts of the matter, have a look at whether the common law principle would apply and simply extinguish, draw the line. Yes, that was before last week, but now it's a totally different situation. The danger arises is if you wish to continue in some other form in an employment relationship with your existing staff. That raises all kinds of interesting possibilities. And I would suggest before you go that route, just give me a call, arising from your attendance at this webinar, and I can possibly ask you a few questions and give you some further guidance in that regard.
Absolutely. So for those of you who have asked questions or who want to ask questions, or if you would like us to just give you a call to get a little bit more information, to give you the right advice, please feel free to just either drop me your phone number, or as I said, you'll have our contact details. Feel free to reach out as well. So Basil, looking at what we should do now, we talk about, you just mentioned, these are some of the things that we, contractually that we've got to be aware of. We've got to be aware of, the labor side of things, the legal side of things. But how do we move forward now as employers, having to address or to, I guess, face some of these things that we have to now deal with?
Chrystal, looking at this slide, it expresses both sentiments or feelings or emotions that the employees and employers may feel. And so the emotional impact of how we feel is not confined to just employees under the circumstances. It's also employers. But employers are normally very, very reluctant to share with their employees how they're feeling. And so this is an opportunity for you as an employer to be honest and open about the situation which exists, because you have a purpose going ahead now, whether to close your business and why you wish to close the business. You could explain that, and that would enable you or provide you with the opportunity to engage with one another in a brutally honest and open way. No hidden agendas, no ulterior motives other than to present to your employees the facts of your business. And that would then enable them to basically identify a purpose in their lives, and to make decisions independent of their employment relationship which they had. By demonstrating that kind of engagement, or while engaging with your employees, it will, and it might shock them, because perhaps in your employment relationship you've never demonstrated undue sympathy or empathy or care for your employees. If the bigger the business, the more impersonal the relationship tends to be. But in a smaller business, and I use the term respectfully, in a moms and pops business, there is normally a higher level of familial care expressed by employers towards their employees. And so by demonstrating that care for your employees under these circumstances, and also sharing with them how you feel about your business being destroyed, you will be able to communicate the sentiment that they are actually valued, and that they, in hearing your side of the story, could actually express an understanding of how you should be valued as an employer under the circumstances. So emerging from that kind of expression of care is a mutual understanding of value, how each are valued by and to each other. Then, by sharing information about the future and answering the questions such as what, why, how, when, about the current situation, you are actually sharing information. And with that information that you're sharing, they and you, in gaining information from them in your engagement with them, are able to be better informed and to make decisions and come up with solutions for the future.
Yeah, and this is
And then,
also, Basil, by
yeah,
doing this, we touched on the science of emotions in the beginning. This is how we move people from that state of feeling threatened, where they sort of stuck. They don't have the ability to logically think about what to do. By doing these things, by giving people the feeling of feeling valued, feeling empowered, feeling informed, we move them from that state of feeling threatened into feeling empowered, where they can now make better decisions. They can behave in a certain way that is more productive and actually facilitates performance. And that is how these are connected. The information that you've got now, it gives you the opportunity to engage with them in a way that you might not have done before, to shift them from experiencing those unpleasant emotions that we spoke about into the pleasant state. And that's, what you were touching on now, is the way we communicate this information to our staff.
sure. We'll look at the slide coming, the next few slides. And
Sorry. Oh.
No. You will then get an appreciation of what you can anticipate from your employees going forward, and then how to deal with that. Okay.
Right. So communicating.
So, yep, absolutely. Just communicate with the staff regarding the decisions, your decisions, and what are you going to decide, and why you are making that decision. Now, whether they accept it or not is, in fact, their prerogative, but at least you are attempting to explain by sharing of information as to what has happened or what will happen and why it will happen.
Basil, is it sufficient to tell them just once? So how you're talking about here regularly. What does that entail?
Yeah, I'm going to be personal now, and my wife's not here listening, but in our marriage, she has told me in her language 10,000 times. Right. And I'm not going to say I still haven't got the point, but that's what it actually means. It's to layer and layer and layer communications so that it seeps in, so that there's understanding and acceptance. And that is what we're talking about here. It's addressing the what and the why so that there is understanding and hopefully acceptance. And when you have understanding and acceptance, you're on the way to consensus.
Right. 10,000 times.
10,000 times.
Some recommendations. So
Yeah,
different ways to communicate with them.
absolutely. It's likely that if their employment is going to be terminated, there may still be outstanding benefits which they are due in terms of leave pay, any kind of provident fund, etc. So it may well be that some of your staff are not staying close by and will have to commute. And some may, under times of duress such as this, they return to their homes. And some of those homes may be farms some distance away. So have a look at being novel and get a hold of all their mobile numbers and open a chat group. And you communicate with them through mobile phones on this chat group as to when, why, what, how, etc. And it'll save them traveling unnecessarily.
All right. And then the compliance factor.
Yeah, I alluded to that earlier. Please be sure that you remain compliant with employment law in the process of settling any pre-common law extinguishing of the contract obligations that may exist. In other words, there will be leave pay outstanding, provident fund, medical aid, insurance, etc. These may be due to the staff, and it's going to be interesting to see whether, in fact, you will be in a financial position or not to pay leave pay that's due. That would be extinguished and all your obligations would be extinguished, but a provident fund is not held by you. It is held in a trust, as it were, by an intermediary, whether it be an Old Mutual, Forbes, whatever the case might be. And in which case, those monies would still be available and due to those employees. You might have medical aid, some kind of benefits which the employees are still entitled to, which are covered by an insurance that was put in place. Those will be. Yeah.
And so, I mean, this is a key point that you touched on earlier, Basil. Yes, it's good for us to operate within the law, but we have to remember the human element. You have to communicate as often as you can, as clearly as you can. And some of these conversations are difficult. Think about how you're going to be triggering people. How are they going to experience the conversations? You know, do you need help with, you know, how am I going to say it? Think about it, plan it, make sure that if you were told that, how would you feel about it? But the reality, as you said, Basil, I have to realize that people are going to be making life decisions based on the communications, the way we're communicating some of these things. And so sometimes being nice isn't the best method. It's about being open. It's being honest. It's about being vulnerable. You know, we touched on these earlier. How do we want people to react? How do we want people to feel based on the way we're communicating? Where do you see most of your staff landing when you're communicating that to them? And how can you move them from this space into that productive space? It doesn't, you know, we're not saying that everybody's got to walk around being positive all the time. It's about acknowledging what people are feeling. What is it that you're noticing in people's behaviors that might give you a clue as to what it is that they're feeling so that you can address that?
It is likely because of historical precedent or practice or culture, whatever the case might be, that employees will seek relief via the structures. Um, it may well be that they do not understand fully the complexity or the simplicity of common law, and still believe that you as an employer have an obligation to them. And they will maybe resort to structures with which they are most familiar or their friends are most familiar. And you might find yourself being faced with a whole lot of applications to the CCMA based upon some unfair labor practice. Simply because looking at the slide here, there is uncertainty, they are stressed, they are anxious, they are worried, they are fearful, and those emotions will manifest themselves in being aggressive and reactive and problem focused and blame. And you as the employer, being the closest, will bear the brunt of these things. So there may well be this raft of unfair allegations coming your way, in the form of CCMA applications, or employees only knowing that route in which to seek relief from what they perceive to be unfair treatment. Somehow, there is this positive expectation from employees that, notwithstanding the fact that your building is busy smoldering, that somewhere you have a bank account or a suitcase filled with millions of rands which they can tap into to receive relief. And in fact, that may not be the case, but anticipate such and prepare for it.
Right, and then just for the sake of time, I know we're running out of time, and I do want to have one or two extra questions here. But this is really what you've said, is we've got to be aware of the far-reaching impact, and when people respond or react, be prepared for that. Would you be able to tell the commissioner that you did everything in your ability, that you did everything within the law to, do what it is that you could, but did you comply? Can you show that? Can you communicate that you had these discussions with your staff, as opposed to leaving people to try and figure it out for themselves? So what Basil's done is he's also, for those who have the need to claim from insurance, because this can sometimes be very confusing, is where do we start? Basil, you know a little bit more about the SASRIA claims side of this kind of event, where people should start. But here's an 11-point checklist for you, which again, you will receive post the session. And I'm not going to go through it at this stage, Basil, because I think there's a question here that's actually, it's probably more important for us to focus on. But know that you have the opportunity to go and look at how you can claim from your insurance, what you should be doing. If you haven't done it yet, these are some of the guidelines that you can follow. But a question: does an employer need to have a mediator, interpreter, and witness present at these meetings with staff? So, where you're going to communicate what's what the business is sitting at right now, potentially what the situation or the state of the business is, or where the business needs to go going forward.
I'll try and be brief, but it's difficult sometimes for me to be brief because there are so many loose ends, and I hope to tie them all up, but it's impractical. This takes us into the realm of evidence down the road, should you be faced with a dispute which is in a court. There is a contract exists verbally. It does not have to be in writing. So a verbal commitment or a verbal offer and an acceptance of an offer is in fact a binding contract at law. However, when it comes to prove in a court that a contract was entered into, you want to avoid the situation of he said, I said, no, he didn't, no, you did. And in the existence of a verbal contract or a verbal agreement, that tends to happen. So if you are entering into discussions with your staff and you do not have any kind of record of those discussions other than what you said and what they said you said, you open yourself to unnecessary disputes down the line. So how do you overcome that? It is legal and lawful, and you are entitled to record any kind of communication, including a telephone communication, which you are party to. So you can, in fact, record a telephone conversation with or without the other person's knowledge, where it is you and that person engaging. Or you can record a meeting where you are personally in the meeting with your employees. So recording in forms of electronic recording is perfectly acceptable under those circumstances. Interpreter, remember I mentioned to you understanding and acceptance. An interpreter, if Zulu is the medium in which the employees prefer and can only reasonably communicate, then bring in an interpreter. It also helps in the recording process. If you are recording things, it shows that you are eminently reasonable by actually having had an interpreter present to assist the employees in arriving at understanding and acceptance. Does that touch on all those parts here, Chrystal?
I hope so. Please, for those who have asked questions, as I said, if you need further clarity, just a question from my side, reading that, can this person be anyone, Basil, or does it need to be someone who is in, whether it's in the company, in HR, or should it be a third party member?
It depends on your relationship with your staff. If you have an aggressive relationship or a tense relationship, a third party could introduce an atmosphere or a spirit of calm and neutrality. You do not necessarily need legal presence in such things. You will see very cleverly at the end of this presentation, I have put in a disclaimer, simply because people may take things and deem it to be legal advice. And the term legal advice is reserved for the legal domain. I am not an eternity, although I'm not an eternity. I am not a legal, I'm not part of the legal fraternity, other than I specialized in labor law at varsity, postgrad, etc., etc. But I am not able to write a letter as an attorney would write a letter or a note or whatever the case might be, which can then be deemed to be legal advice. So if you fear that you are going to end up in a conflict situation, which could end up in the labor courts, then seek legal advice from your friendly attorney, but make sure that it is a labor attorney and not a criminal attorney, in the sense that criminal and commercial law or civil law is a very different animal from labor law. So seek advice from a labor attorney, should you wish that. And if you require, it's once again horses for courses. If you want a street fighter, a labor attorney, I can recommend you to a street fighter. If you want a theoretical or academic labor attorney, I can recommend you to labor attorneys. So should you need references or referrals to labor attorneys, I'm more than happy to share those with you, and you can make the choice as to who you wish to consult with.
Thank you, Basil. And then just, for time's sake, this is how we are offering to help you today. We've got a complimentary survey. So if you want to get an idea of what people are currently experiencing, this is based on research. If we know how our people feel, we can predict their ability to perform and engage as effectively as they need to. It also helps us figure out what kind of things we need to do as those engaging with them to move them from some of those negative triggered states into positive productive states. We can help you remain legally compliant. So Basil's just touched literally on a few of the questions that were asked around legal compliance. If you need help recovering based on what's just happened, or if you need to redraft important HR documentation, as well as the unfortunate side, having to deal with drafting those termination letters, suspension letters, downsizing or restructuring, please feel free to reach out to us. We can help you in that way as well. And then our contact details will again be sent out to you. So please feel free to reach out at any point. As I said, we'll do what we can. And Basil just mentioned he knows all the fighters in all the different zones. So depending on what it is that you need, he's got the connections. We'll stay on for a few minutes extra. So if anyone does want to stay on to ask any additional questions, we will wait here. Alternatively, if you need to drop off, that's fine. Look out for the link in the next few days. We will send you this PowerPoint presentation with some of the points covered, as well as our contact details. So reach out at any point. Basil, any last comments from your side?
No, just thank you all for being in attendance, and I perhaps.
Sorry, you lost your sound, Basil.
A small cube within the little while. Happy to chat with you.
Thank you. Thanks for attending, and thanks for all your input and additional questions. And yeah, as I said, we'll just wait here. We'll wait a few minutes extra. Otherwise, you feel free to drop off at any point. Let's see. Right, if we've got no questions, I'm going to end the session. Oh, right, here we go. Basil, here's another one for you.
Sure.
So if you have different categories of staff, like your cleaners, your admin, drivers, would you have all the staff attend the same meeting, or would you have separate meetings for each of those categories? So if bargaining council is involved, how do you address this?
Okay. It really depends on the purpose of your communication. You know, some communications can go out to all and sundry and are applicable to all, but other communications need to be effectively tailor-made to the market segment, if I can use that jargon. And so there may be specific terms and conditions or specific items which are unique or discrete enough to be dealt with with one group, then communicate with that one group and tailor make your communications accordingly. If you're talking about a general notification to staff that, look, the business is closed, no longer operating, then all and sundry together would be appropriate. So in answer to your question, it really depends on what you want to accomplish and with whom you wish to accomplish that. And the third part really in sort of business communication is to tailor make the communication to the audience so that you are able to optimize the content of your communication. So for example, and I'm not sure of the experience of the person asking the question.
So let me ask Jane. Jane, if at any point if you want to come off, I mean, it's up to you if you want to come off mute or video, and then we can just, Basil can help address that question for you, if that would be helpful, or perhaps provide more context, and I can pause the recording. If it's something you don't necessarily want to ask on the recording. Jane?
Hi, can you hear me?
Yes. Do you want me to pause, or are you happy to ask while being recorded?
I'm happy to record. It's no problem at all.
Thank you.
So it's just that we have two sort of sectors of employees as drivers who are with the bargaining council, and then and then cleaners and admin staff who are separate to that. And so I'm just not sure with the bargaining council and the restrictions that they impose, how so they're not really included under the admin contracts. So, bargaining councils are quite a tricky situation, and I don't know if we can negotiate without the bargaining councils being informed, and how we can negotiate sort of shortening of hours or anything like that.
Jane, thank you so much for your inquiry. The first question I ask is the business likely to continue trading?
It's hard to say. It's hard to say. Yeah, we're still trying to sort of downsize, I think, and with the possibility of having to perhaps close down.
Okay. Jane, under those circumstances, I would strongly recommend that when you say the drivers are part of the bargaining council, which bargaining council do they fall under?
It's the national
road freight.
Yes, yeah, road freight.
Okay. And your business as such, are you as a business placed within the road freight industry, or is it just one element of your business? That's
no. So we are courier service.
Oh, right. Okay.
So our drivers are contracted. We have a business that has actually contracted the drivers, and then we created a second business for the admin staff, so that they wouldn't be part of the bargaining council under the road freight situation. So basically, the admin staff are contracted into the company where the drivers work, but they're two separate companies.
Okay.
But it is for a freight company, so we are sort of under the umbrella of a freight company.
All right. I'm going to say the worst case scenario, but it could be the best case scenario. Let's supposing that all your staff were dealt with or treated as if they were within the road freight bargaining council. The first decision would be if the business is going to close, in fact stop trading as a result of what has happened, then the common law principle would apply, and it would be then simply a communication to the bargaining council advising them on the basis of supervening situation of facts that the business can no longer continue, and that would effectively terminate your membership in the bargaining council as an employer, blah blah blah, etc. If, however, there is some glimmer of hope that you can continue training, and you mentioned words such as trading, that you can and you can operate in certain areas, it raises almost then the obligation that your business has not been destroyed as such. You won't be able to then call upon the intervention of common law, and you would then need to conduct a downsizing exercise, if you want to call it that, or a restructuring exercise, which would then need to be done in accordance with the provisions of the Labour Relations Act. And it is likely then that by downsizing or restructuring, you would then be terminating the contract of one or more employees. And the grounds for termination of that would then be the adverse impact of the protests or the riots or whatever the case might be. So in terms of the Section 189 of the Labour Relations Act, you need two pillars, as it were, to proceed. You need a substantive pillar, which is, in our understandable language, is good cause, good reason to effect a downsize or a restructuring, all right? And the other pillar is the process which you follow. Now, where the reason is so overwhelmingly apparent, that you do not need a rocket scientist, or you do not need lots of intervention of information to support it, it becomes then almost superfluous that you then proceed with an extended downsizing process as per the Labor Relations Act. I'm not saying you can do without it, but the substance is so strong that it would in fact enable you to truncate or shorten the consultative process with your staff. So you wouldn't need to go for months and months and months engaging in lengthy negotiations or consultations with your staff. It would be, in fact, very brief and could be done within a matter of a few meetings. However, if there are staff who fall within the bargaining council, all right, the bargaining council of the road freight industry, and I'm not 100% familiar with it, but I can come up to speed and give you some better advice. But the road freight bargaining council may in effect have specific clauses pertaining to the Section 189 termination or retrenchment of staff within the council. In which case, if you then embark upon that, you would need to follow the provisions of the terms of the bargaining council agreement as they apply to retrenchment. Does that help you?
Yes, thank you. That's a lot to try and absorb there.
All right.
Thank you very much indeed.
Jane, the starting point would be, okay, and please, I'm a little bit concerned where you have two companies, and I understand the reason for that. But if I would suggest that if you do have two companies and you are going to be affected, or you both employees from both companies are likely to be affected, deal with what is clearly under the bargaining council through the bargaining council, and the other company, which if it's a clear division between the two, deal with that in terms of the straight Labor Relations Act Section 189 processes. Right, so conduct a dual process, one in terms of the bargaining council and one in terms of Section 189 of the Labor Relations Act straight out.
Okay, that's very helpful. Thank you.
Sure.
Yeah.
Okay.
Jane, if you need any help, please shout. Leanne, Viv, do you have any questions?
No, nothing right now. Thank you very much. This was very helpful. I really appreciate it.
You're welcome.
Sorry, Crystal.
Yes.
Actually, there is something I've been thinking about. So if you haven't completely, if you haven't, if you're going to have such destruction to your business, and you want to try and continue to
trade.
Hello.
Hi.
Sorry, I think I've got.
Have you lost Crystal, Leanne? All right.
No, I'm yeah, sorry.
Okay. All right.
I just went quiet.
So as I was saying, if we wanted to continue to try and get the business up and going again, but of course with this type of loss, if at some point we weren't able to sustain it, or we had to reduce the number of staff, is that something we could do after a month or two?
Leanne, if you are going to continue and communicate to your staff that you are going to continue, there would be the expectation from their side that they would be paid.
Yes.
So if you are making any plans to resuscitate the business and such the like, I would enter into a negotiation with them to suspend the contract of employment. So you're not terminating them, but you're suspending and you would draft some terms of suspension so that they clearly understood what that implies, especially if it's a situation where you're going into it in an exploratory way. You don't know at this stage whether it will or will not work out. All right, and I'm not putting words into your mouth, but that's what I'm meaning when I'm talking about exploratory stage or an approach.
Okay.
During that time of uncertainty, you would suspend the contracts. Now, that suspension of the contracts would then be drafted in an agreement with your employees, and you would give yourself some what I would say milestones or benchmarks along the way, which would enable them and you to determine whether this thing is going in the right direction or not. And it will also enable you to put it into some kind of chronological or time frame, so that if certain targets for the revival of the organization not met within certain time frames, that would then immediately mean exit clauses along the way. So you wouldn't be bound, say, for a period of 6 months to pay the employees or part pay the employees or to have them hanging on for an indefinite period. There would be exit milestones, or to use, just graphically, imagine a road with turnoffs along the way. And those turnoffs would be at 1 month, 2 months, 3 months, 4 months, 5 months, whatever the case might be. So you would put those into the agreement as well, which would protect you and your staff. Does that make sense?
Yes, that does. Thank you.
Great. What those turn-off points or exit clauses would be would really depend upon your business and how you would actually be going about reviving the business.
Okay. Right.
Hope that
Thank you.
helps, Leanne.
Sure.
Yes, it does. Thank you.
You're welcome.
Leanne, thanks for attending.
Thank you. Thank you, everybody.
You bet.
And Viv, I know that she's in between here and there. Yeah, if there are no further questions, Jane, all the best with what it is that you need to do. And again, reach out if you need any help. Basil, thank you again for adding your expert advice and for being here to support the members of our business communities.
It's a pleasure. Thank you. Thank you all.
Take care.